Hello and welcome to this episode of Social Issues of Recitals. This is September and these are the themes we're discussing. We'll be discussing changes to the rape laws that have been made. We'll be discussing health and we'll be discussing the Supreme Court judgment on child pornography. Hello and let's discuss the Aparajita Bill. As most of you would be aware, there was a horrific rape case in Calcutta in the R.G. Kar College and Hospital, and where a girl was brutally raped and murdered. And this has evoked intense reactions from across the country. And even in Calcutta, there have been intense reactions to this. And as a response to this, the West Bengal government has made some amendments to the existing rape laws in the state. Now, let us discuss this in greater detail. What generally happens is, this bill is making changes to the concurrent list. So let us discuss what it is, what these changes are, and how it's to be done legally. The Aparajita Woman and Child Law Amendment Bill. Now this mandates death penalty in rape cases if the victim dies or is left in a vegetative state, which is to say, if the victim goes into a coma or if the victim dies, then death penalty would be mandatory. That is not the current law under the BNS that was recently passed. Now, the other thing is, these are the amendments that are being made. Now, Indian laws that curb on sexual assaults on women, we have the Criminal Law Amendment Act of 2013, which amended the IPS, Indian Penal Code. Now, this, of course, has been replaced by the BNS, Bharatiya Nyaya Sanhita. This was the first bill that allowed death penalty in cases which led to death or victim in a persistent vegetative state, and in cases of repeat offenders. Now remember, death penalty in India is bound by the Supreme Court judgment that says rarest of rare cases. Death penalty is only in the rarest of rare cases. This is the Supreme Court position, rarest of rare cases. So this is the Supreme Court position currently. Now, what the West Bengal government has done is they have made changes to the Criminal Amendment Act, which provided for 2018, which provided for death penalty in case of rape and gang rape for children, for girls below the age of 12. Now, the Bharatiya Nyaya Sanhita, what we did was, it keeps the old penal provisions and adds another provision. It says that under the age of 18, instead of under the age of 12, there can be death penalty given to the people. Now, what are the salient provisions of Aparajita Bill? Like I said, the bill amends the BNS, and what it does is, it basically says it actually increases the quantum of punishment in many cases where there are aggravating circumstances present. These are the provisions of the Bharatiya Nyaya Samhita, such as rape by a public servant. The bill adds a word or with death. This is the BNS. Okay, this was passed in 2023 and this is the BNS. Now what? And in rape cases where the victim dies or is left in a permanent vegetative state, the BNS says death penalty can be mandatory in such cases. Now, in case of gang rape, bill provides for death penalty for a woman above the age of 18 if these conditions are met. For repeat offenders, what the Aparajita Bill is saying is, replaces the punishment of simple imprisonment with rigorous imprisonment for life. Now, disclosing the identity of a rape victim is prohibited under our law, and many cases, there have been a few cases where maybe inadvertently or maybe deliberately the name of the victim has been let out, and that attracts a penal provision. They can be sent to prison. Now, that has been also increased in terms of the jail term under the Aparajita Bill. In case of acid attacks, the bill removes the lighter punishment of prison term less than life and fine, and it includes rigorous imprisonment for life. So these are some of the changes that have been made. Now, there are also changes that have been made to the POSCO Act. Now, the POSCO Act is Prevention of Sorry. Now, the POSCO Act, as you know, is a prevention of offences against child sexual assaults. So these are actually this is a pretty stringent act, and even in this case, the bill provides for death penalty in this case. Now, the provisions of BNSS that have been amended, bill reduces the time provided under BNSS to complete the investigation from 2 months to 21 days. Now, one of the problems that was seen recently among the protests were people were extremely angry and they wanted results faster. And one of the problems we have in our country is cases drag on for years. Now, there's a reason for this, and the reason is across the world, let us say in countries like China and USA, there are 270 judges per 1 million people. In the case of USA, it's 300 judges for 1 million people. In the case of India, it is just 21 judges. Now, this is a major reason why cases drag on forever. Now, however, that's also the reason why people get so angry, why there's such little faith in the judiciary, why there's such little faith in the system as such. So what the Aparajita Bill has suggested, or rather he has tried to amend actually, is to reduce the time given to complete the investigation from 2 months to 21 days, which can be extended by 15 days if necessary. Now, the bill also reduces the time given to complete the trial from 2 months to 30 days. Now, these are actually very, very difficult targets to meet. Remember, right now, 78.06% of the people in prisons are under trials. Which is to say only 22% approximately of the people in prisons are actually convicts. 22% are only convicts. This is a testament to the fact that it takes forever to actually complete cases in our country. Now, the Aparajita Bill also says that it allows for special institutions like special police teams to investigate crimes against women, with the express purpose of hearing and deciding rape cases on strict lines. For example, it creates a special Aparajita task force. Bill also introduces special courts in every district for the purpose of expeditious completion of the inquiries, and also appoints a public prosecutor for this. Now, there are other similar laws that have been attempted by other states in the country. Now, before West Bengal, Andhra Pradesh has passed the Disha Bill in 2019, and Maharashtra passed the Shakti Bill in 2020, both of which gave actually death penalty for rape by amending the criminal laws in force. Now, remember, these are still before the BNS came in 2023. But they did not get assent. Now, earlier the Madhya Pradesh and Arunachal Pradesh introduced death penalty for rape or gang rape for children, for a woman up to the age of 12 years. Age of 12 years, we should be actually calling a child. In the case of child, this has been incorporated into the BNS 2023. Now, what are the difficulties in introducing these changes to curb sexual assault laws? First is, there was a case called Mithu versus State of Punjab. The Supreme Court ruled that mandatory death sentence for any law violates fundamental rights of equality before the law. And also says, they also observed that it would result in unfair, unjust and unreasonable procedure that would endanger life of the citizens of the country. Now, we need to remember one thing. Why are these three bills, rather the Andhra Pradesh bill and the Maharashtra bill and West Bengal bill, why have they not been put into law? Now, whenever we have a case under that involves anything in the concurrent list, a concurrent list basically says that both the state and the center have a right to legislate on that. Now, when the state makes a law that overrides a central law. Generally, when a state makes a law, what happens is the governor gives an assent and it becomes a law. However, when it comes to a concurrent case, when a state makes a law that goes, or rather tries to override a central law, the governor has to give an assent and then it has to get the presidential assent as well. Only then can it become a law. Now, this is a point we've discussed in the past as well. In one of our previous episodes, we discussed how the Himachal Pradesh government was trying to change the laws in the context of marriage. They were trying to increase the minimum age of marriage for girls, and they were trying to bring it at par with boys. And that law again goes against, or rather tries to override the existing laws of the center, which is 18 years and 21 years. And for the same reason, it's lying with the president. Now, what happened ultimately in this case is on September 6th, the West Bengal governor, C.V. Anand Bose, reserved the Aparajita Bill and has sent it to the president. So now it will be up to President Murmu to decide whether this will become a law or not. Now, what are the major differences between the West Bengal legislation versus existing law? In the West Bengal legislation, death sentence if the victim dies or is left in a vegetative state. Now, the existing BNS law says if rape results in the victim's death or leaves her in a vegetative state, death is only one of the punishments. There are other punishments like life term or minimum 20 years in jail. Now, Aparajita Bill is saying that there will be mandatory death sentence. Now, the other thing Aparajita Bill says is establishment of special courts for sexual violence. And existing laws, we already have a sponsored scheme after the horrific case in 2012, where what is commonly called the Nirbhaya case. There have been a lot of changes, and now there is a centrally available fund which can be used actually for all this. So there is a scheme that is actually gives money to the state government to set up fast track courts and all. So they can draw money from that for fast track courts. That should not be a problem. Now, the West Bengal bill, the Aparajita bill, has also reduced the number of days available for investigation from 2 months to 21 days with a provision for an additional 15 days. Now, existing laws, like I said, is 60 days. Now, that has been changed. Now, the junior doctors are continuing to protest in the state. And the other change that has been made is disclosing the victim's identity. Under the BNS, it's only 2 years. However, and there would be a fine as well. However, the Aparajita bill is saying that imprisonment of 3 to 5 years. So that is the other change that has been suggested. Now, why is the president's assent crucial for this bill? Like I said, it's in the current bill affects the 7th schedule of the Constitution. Schedule is nothing but a list. We've discussed this in the past. We have several schedules in the Constitution. Schedule basically is just a synonym for a list. Now, it's in the 7th schedule of the Constitution, which basically means both the center and the state can make laws on this. And it's a criminal law, and criminal procedures are in entries 1 and 2 in the concurrent list. Now, there are 3 bills, like I said, Aparajita, Disha and Shakti, which are basically going against, or rather, which are going beyond, or in a way, the technical term would be they're making repugnant the original law, because of which we have to have a presidential assent. Now, today we are doing something slightly different. At the end of every topic, we'll try and discuss if there have been any questions in areas that are similar to this topic or on exactly this topic. So, on this issue, there was a case, there was a question in the previous years. In 2014, in the mains exam, there was a question which said, we are witnessing increasing instances of sexual violence against women in the country. Despite existing legal provisions against it, the number of such incidences is on the rise. Suggest some innovative measures to tackle this menace. So there was a question like this. When you listen to a topic, it's better to actually try and see if there have been any questions. So that gives you an idea of how in the coming exam, you might face questions about this. So this is how a question was framed when it came to this issue. It was almost 10 years ago, so it's a realistic chance that it will come again. Now, let us discuss new draft guidelines for passive euthanasia. what is euthanasia? Have there been any questions on this? And what are the new draft guidelines? Let us discuss this. Now, draft guidelines for withdrawal of life support, that is what, which means that it's not really the law right now, but the government is trying to introduce certain changes. So these are basically draft guidelines for withdrawal of support in terminally ill patients. Now, what the government is saying, this was released by the Union Health Ministry, and feedback and suggestions have been invited from the stakeholders till October 20th this year. Now, right now, there is no formal legal framework which regulates euthanasia in the country. There are Supreme Court guidelines and there are procedures that have to be followed, but there is no law which covers this. So, this is what the court, this is what the government is trying to fix. What is euthanasia? Now, euthanasia is defined as the hastening of death of a patient to prevent further suffering. It's basically, in a way, a patient can decide to end their own life. In a way, it's a form of suicide actually, but under extreme medical pain, extreme medical duress. So the word suicide is not really used here, but in a way, it's a form of suicide. Suicide is no longer a crime in the country. That has been changed. Now, when was this word first used? Now, the term euthanasia goes back to the historian Suetonius, who described how Emperor Augustine, he died quickly and without suffering in the arms of his wife Livia. And this is the first time this word was used. In the context of Emperor Augustus, the historian Suetonius used. These are the kind of things sometimes can come in prelims. Now, in the modern context, the word, it was English philosopher Francis Bacon who used the word euthanasia early in the 17th century. Now, euthanasia, the word, is derived from two words, EU meaning good, good, and then we have thanatos, which means death. So basically, it's saying a good death. So it's a good or a easy death. So this is where it started, and these are the early usages. Now, what are the types of euthanasia that are currently there? There is a typology of them. Let us discuss that. Now, we basically have two types. One is called active euthanasia, the other is called passive euthanasia. Active euthanasia in our country is illegal. It's a crime, and only those who are brain dead can be taken off life support. We'll discuss those details in a minute, but active euthanasia in our country is completely illegal. Now, the government is not trying to change that, so we don't have to start getting worried about has the government made some major changes. Now, there are three types of active euthanasia. We have voluntary euthanasia, which is at the patient's request. We have involuntary euthanasia without the patient's consent. So the patient is no longer in a position to give consent. Now, the third, non-voluntary, then the third is involuntary, where a patient is not in a position to give consent. So these are the three types. One, voluntary, where the patient is giving consent. Non-voluntary, where the patient does not give consent. Involuntary, where the patient is no longer in a position to give consent, but maybe they have made a will before, which is called a living will, and they have already said that in a situation where I am not able to make a decision about this, I may be permitted to die. So these are the three types. Now, the one we are actually discussing today, or rather the government is trying to regulate, is what is called passive euthanasia. Passive euthanasia refers to intentionally withholding or withdrawal of medical treatment which allows a person to die naturally due to an underlying condition. Maybe somebody is suffering from cancer or some maybe HIV/AIDS or any terminal illness. If we stop the treatment for that person, realistically the person will die. Now that is called passive euthanasia, and which is what the government is actually trying to regulate, and we're trying to, this is what the draft regulations are going to cover. Now, passive euthanasia can include stopping treatments like ventilators. This is very common, feeding tubes, or medications that keep the patient alive. So it can be like you just turn off somebody's ventilator. In terminal cases, many times people are no longer able to breathe. So it's only the ventilator, which is called a BiAPS machine, that keeps a person, that actually allows a person to breathe. So on their own, they'll not be able to breathe. In that case, if you turn off the ventilator, the person would die. Now that is passive euthanasia. Now the other thing is feeding tubes. The person may not be in a position to eat anymore. So you have feeding tubes that go through, we have what is called a tracheotomy that is done here. The cut up bit here in the throat, and through that food is passed in. So if you stop feeding, the person may again die. That's also again passive euthanasia. Now, the other thing is you can stop medications that are actually keeping a person alive. So these are the three types which can be called passive euthanasia. Now, decisions for passive euthanasia are typically based on patient's wishes, advance directives, or through family members and healthcare professionals. Now, in the case of India, we have had some interesting cases, like there was a case called Common Cause versus Union of India in 2018, which recognized a person's right to die with dignity as a fundamental right. Now, this is an important distinction, that a person has a right to not only live, but to die with dignity, and this is covered under Article 21. So, because of Article 21, which gives us the right to life, a person has a right to death as well, to die with dignity. Not only should we live with dignity, can also be allowed to die with dignity. Okay. Now, terminally ill persons can opt for a passive euthanasia and execute a living will. This idea is accepted legally in the country. It's called a living will, where a person can say that should I reach a position where these conditions come into play, I should be allowed to die and not be kept alive like a vegetable, which is, nobody wants to be in a vegetative state, not in our country at least. We believe in rebirth and things like that. Our philosophy about life and death are quite different. So this idea of a living will is actually recognized in the law, recognized by the Supreme Court actually. The draft guidelines on passive euthanasia, these are the draft guidelines. These are the highlights of the draft guidelines. Now, what they say is it defines terminal illness. First, because basically if you're talking about euthanasia, it's necessary to define terminal illness. Otherwise, cough and cold can't be called terminal illnesses. So we have to define it. Now, it defines illness as an irreversible or incurable condition for which there is no cure in the foreseeable future. That's the first. Now, this has to be based on 4 conditions. First is the individual has to be declared brainstem dead. This is the first thing. They have to be declared brainstem dead. There is a medical assessment that the patient's condition is advanced and unlikely to improve with aggressive treatments. That no matter what you do, this person's condition cannot be improved. That is the second condition. The third is the patient or surrogate has to provide informed refusal to continue life support after understanding the prognosis. The patient must be in a very clear state of mind, must say that I don't want to continue this treatment. Now, the procedure follows the directives set by the Supreme Court. In case this is not possible, then we come to the idea of a living will. But these are the draft guidelines right now. What are the provisions related to advanced medical directives? Guidelines also mention advanced medical directives where individuals document their treatment preferences. In case they lose their decision-making capacity, in case they're not able to make decisions, they can always say, this is how we want to be treated. All part of right to life, remember that. Now, this has to be referred to a medical board, primary medical board, and if the medical board agrees, a shared decision is made with the family and a secondary medical board's approval is necessary. So this is how the procedure is under the draft guidelines. Now, what are the provisions and safeguards? Halting or withdrawal of artificial life support in case of incurable illnesses. This is already the case in countries like Germany, Canada, South Africa. They allow it. active euthanasia will continue being illegal. It's done by administering lethal substances in countries like Belgium, Netherlands, Colombia, Japan, but India has said that active euthanasia will continue to be illegal and it's not part of the draft guidelines. Now, living will be recognized. It will allow patients to give explicit directions about what they want to be done in case they are no longer able to make their own decisions. Now, in case of execution, families, patients, or next of friend can approach family or family member or next of friend can approach the courts for making a decision, and they have to approach actually a high court, which will then refer the case to a medical board, which will take study the entire case, then come up with a set of guidelines about what needs to be done. It will be on a case-to-case basis. What will happen next? Right now, there are Supreme Court guidelines in place until a law for passive euthanasia is passed. So that will continue to be there. And the center has also proposed a law, the medical treatment of terminally ill patients, 2006, that is still yet to be passed. So this is where this stops. Now, this is one idea that you need to be aware of. It's called euthanasia versus physician-assisted suicide. Now, these are two ideas. Physician-assisted suicide is basically a physician providing medications or advice to enable the patient to end his life. While there are theoretical and ethical considerations that come into play, the differences are subtle, but this is a major difference when we talk about euthanasia and physician-assisted suicide, because physician-assisted suicide has led to a lot of cases around the world, like you must have heard of Kevorkian and people like that, who was called Dr. Death and all, because they were helping people who are suffering by giving either medications or telling them how they could end their life. Now, what is important is many patients who are terminally ill, they actually already have access to lethal medications, or they can even get at the request of their physicians, but they do not end their life using that. However, a physician can assist them, in ending their life. So that is where it becomes a physician-assisted suicide. Okay. So this is an important distinction in this case, in this category. Now, what are the terms used in end-of-life scenarios? We have active euthanasia that we just discussed. We have passive euthanasia. We have voluntary euthanasia, and we have non-voluntary euthanasia. Now, voluntary euthanasia is a person competently requests that I be allowed to end my life. That is where it is voluntary euthanasia. Non-voluntary is when a person is no longer able to make the decision, but maybe has left a will. Now, other thing, like I said, is we have suicide, basically ending one's own life. Then we have assisted suicide, like I said in the case of physician-assisted suicide. Now, there is also murder. Now, one might think, why is murder being discussed here? Because if euthanasia is not recognized and a person helps another person, or then let us say a doctor injects somebody with the intention to kill a person as mercy killing, that would still be called murder. Now, there is non-voluntary euthanasia. A patient is in coma or something and they receive help to end their lives. That would be non-voluntary euthanasia. Now, there is also manslaughter, which is a person does not have the intention to harm but shows gross negligence in their procedure, because of which the person dies. Now, that would be called manslaughter. For example, let us say there is a operation procedure going on, and a surgeon may decide to remove a tumor that might lead to the person's death. That could be considered manslaughter. Some doctors may say, no, we'll not touch it. One may say, I'll touch it, and the person dies. That could become a case of manslaughter. So these are differences, and these are ethical terms that one needs to be aware of when we are discussing euthanasia. Okay. Now, this is where the differences are. You have euthanasia, you have suicide, and you have involuntary euthanasia. We have voluntary euthanasia, non-voluntary euthanasia, active and passive. Okay, so these are the ones. Now, basically, if there is a question about this, it could involve some kind of an argument about what would you say against it or what would you say for it. So let us just understand the basic arguments that are used around the world. This is a huge debate. This has been a debate for many, many years, and these are the main arguments when we talk about this debate. Okay, now what people say is, what are the arguments in favor? Let us first discuss them. People have a right to self-determination, so should be allowed to choose to end their lives when they want to. Now, that is the first thing. So it is your life and it's your choice. That's kind of the first argument. Now, the second is assisting a subject to die might be a better choice than prolonging their life. Let us say somebody is in immense pain due to cancer or any terminal illness. No terminal illness is ever pleasant. So helping them to actually end their life might be considered an act of compassion. Distinction between passive euthanasia and active euthanasia, people say is not really substantial. It is more a question of, usages rather than actually, there are only subtle differences and there's no real difference. That the underlying principle of double effect is unreasonable and unsound. So this is one of the arguments made in favor of euthanasia. Permitting euthanasia will not necessarily lead to unacceptable consequences. And other arguments are, in India we have the right to life, which basically says right to death is also part of it, a right to dignity, right to live with dignity and right to die with dignity. It is the other argument. Now, Supreme Court in a famous case called Giancount in 1996 held that the right to life does not include the right to death. However, this has been changed over a period of time. Now, other thing is there is a caregiver's burden. When we talk of euthanasia, people who are taking care of those who are terminally ill, it's a lot of, it actually leads to depression and other problems for those who are caregivers. There is that argument. The caregiver's burden, their own lives can be, very deeply affected. So it's probably better to allow them to die. That's one of the things. Now, refusing care, the right to refuse medical treatment is well recognized in the law. Established principle, morally problematic, but it is established. For example, now encouraging organ transplantation. This is one thing when somebody chooses to leave their body, or rather chooses to die. And this happens more in the case of brain dead people. There are about 45 organs that can be transplanted. 45 organs can be transplanted from a person who's actually brain dead, who chooses, if they have left a living will or the others choose to allow that person to die. There are 45 organs that can be used. 45 people can be cured. So that is one argument in favor of it. Now, what are the arguments against euthanasia? Not all deaths are painful. There are alternatives such as cessation of active treatment combined with effective use of pain relief. Maybe that's also available. Then there's a distinction between active and passive euthanasia, and that is morally significant. Like I said, those who support it say there's no difference. Now, legalizing euthanasia will place society on a slippery slope because doctors are supposed to cure people. And if they start killing people, then where do we stop? Now, this is not a wild argument. Actually, there have been cases where, we have had very serious problems in the past. In Germany, in Nazi Germany, they started euthanizing people who had handicaps. It started off initially with 8 children, and by the end of it, they had killed off 3 lakh people. So it's actually a slippery slope. If somebody is against this, historically we have seen that allowing euthanasia to happen can lead to horrific, monstrous consequences. So it's not entirely, it's not like people are just making up stuff. Now, euthanasia weakens society's respect for the sanctity of life, especially in the Western societies where they don't have a concept of rebirth. This is the only life they get. So it's also a religious thing. Ultimately, a lot of morality is drawn from religion. Now, euthanasia might not be in a person's best interest. People can be killed off for property, or old people can be killed off for property. We have seen that happen even in our own country. There is, of course, God's miracle of curing the terminally ill. The prospect of discovery of possible cure for the disease, that is also there. So, these are some of the arguments against euthanasia. Now, proper palliative care makes, that is proper care for people towards the end of life, towards when they enter terminal illnesses, makes euthanasia unnecessary. That's one argument. There is no way of properly regulating euthanasia. Allowing euthanasia will lead to less care for the terminally ill and undermines the commitment of doctors and nurses. Then becomes a cost-effective way to treat the terminally ill. So insurance companies are actually going to make money off this. Allowing euthanasia will discourage the search for new cures and treatments for terminal, which is actually a valid point. Then euthanasia gives too much power to doctors. Now, recently there was a case in the United States where a person, they had said that the person is now brain dead, and they said that let's harvest his organs. And as he was being wheeled into the operation theatre, it was seen that he opened his eyes. And when the family members pointed that out, the doctors said, oh, that's just a reflex action, he's not really alive. Now, after he was taken into the operating room, 2 doctors saw his condition and said that no, he's not brain dead, he can come back to life, and refused to do it. Now, the board of people who were actually responsible for harvesting organs, they contacted another set of doctors and said that please harvest the organs. Now, after they opened him, and when the doctors touched the heart, he opened his eyes and came to his senses and started to cry. And they were horrified, and they stopped the procedure. Now, there is a case going on in the United States about this. And the board that was responsible for harvesting the organs said that we did not contact a second set of doctors. Now, the person himself came back to life and was living with his family with minor problems. So, this is actually a very, very dangerous idea, which has a lot more to it than merely, allowing somebody to die or to harvest organs. So, it's a fairly complex case. Now, what is the position in India? Passive euthanasia in India is legal, like I said. Now, on March 7th, 2011, the Supreme Court of India said that we legalized passive euthanasia, allowing the withdrawal of life support to a patient in a permanent vegetative state. So somebody has, actually there is a scale which is used by doctors when somebody has brain surgery or brain injuries or anything like that, that allows them to tell you to what extent their functions are there, to what extent the brain is damaged. So generally it's a scale of 11, and if somebody goes below 3, then it's more or less clear that the person, they cannot move their hands, they cannot respond to anything, then it's more or less that they've entered a vegetative state and there's very little chance of that person coming back. In those cases, the Supreme Court said that withdrawal of life support is possible. Now, there is a case, this has been called persistent vegetative state. There is a very important case, you should remember this. It's called Aruna Shanbhag. This was a person who was in a coma for 42 years. And then the people went to court. There was a friend of court, rather you can appoint yourself as a friend of court, and they approached the court and said, please allow this person to leave her body. And that's when the Supreme Court came up with a set of guidelines, set of laws, and then the passive euthanasia has been legalized. Now, what the law says, what the Supreme Court guidelines are, must be brain dead for whom ventilator can be switched off, those in a persistent vegetative state for whom feet can be tapered off. And then there was also a common cause case in 2018 where the Supreme Court gave a significant judgment, said that right to live with, right to life includes the right to live with dignity and also includes the right to death, right to die with dignity. Now, as India has no laws about passive euthanasia, right now this is what is in force in our country. A decision has to be taken to discontinue life support by close relatives or anybody, the parents, spouse, or close relatives, and such a decision can be taken even by lay people. It can also be taken by doctors, and however, the decision should be taken in the best interest of the patient. Now, even if a decision is taken, it requires an approval from the High Court. The concerned High Court has to give approval, which will constitute a bench of 2 judges, and they will decide whether to approve it or not. And there will be 3 reputed doctors who will be tasked with actually providing the court the necessary documents to show whether what the right decision would be. So this is right now the procedure. And then, of course, once the doctors give the report, the court then gives a notice and finally gives a decision about this. So this is the procedure that has been established by the Supreme Court. Now, what are the changes? In January 2023, that's last year, Supreme Court made some changes. Now, what are the changes that have been brought in? Living will. Now, earlier it was necessary that a judicial magistrate attest or countersign a living will. Now, they said the gazetted officer would be more than enough. A notary, by a notary or a gazetted officer would be enough. Now, the access to the living will be part of the national health record. Earlier, it was kept in the custody of the district courts. Now, primary board to examine the patient condition. There were earlier a board of doctors, at least 4 experts from cardiology, neurology, nephrology, psychiatry, and oncology, with a standing of at least 20 years. Now, they said there are 3 doctors, including a treating physician, and 2 other doctors with 5 years of experience, will comprise a primary board of doctors. Now, time taken, earlier there was no time frame. Now they said that within 48 hours you have to make a decision. Now, the hospital must constitute a secondary board of experts. Earlier, the district collector had to constitute a secondary board of experts. So these are the changes that have been brought in, and this is currently the latest position about passive euthanasia in the country. Now, this is where the world is in terms of where euthanasia is allowed and not. Where you see red, all forms of euthanasia are illegal. So this would be Kenya, and that's Russia. All forms of euthanasia are illegal, not allowed at all. Now, the deep blue, voluntary euthanasia is allowed. And so you can see in Australia, parts of it, they have voluntary, parts of it, they have passive. So, the light blue, these are where you have passive euthanasia allowed. So India has allowed passive euthanasia. And where there is no color, the gray color, active euthanasia is illegal and passive euthanasia is not legislated or regulated. So this is where it is right now. Now, what are the major laws around the world? So Netherlands was the first country to legalize euthanasia. Remember this, prelims, and allowed under strict conditions. The termination of life on request, and assisted suicide is also allowed. And Belgium legalized in 2002. Luxembourg, Switzerland, Colombia, United Kingdom, these have allowed passive euthanasia. Now, Australia allows the right to refuse medical treatments. Canada, United States has a split opinion. I mean, some states allow it, some states don't allow it. Spain has legalized euthanasia. France is considering legislation to legalize a form of assisted dying called aid in dying. Now, there was a question in the past that involved some of the legalities in this. So let us just consider that question. It was a prelims question in 2018. Right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India currently and appropriately imply the above statement? So the correct answer would be Article 21, freedoms guaranteed in Part 3. So this is how sometimes, they may not be directly related, but something's related to something. So that's how this has been asked. So this was about euthanasia. Now, the Supreme Court is strengthening laws against child pornography in India. Let's discuss this. Now, marking a significant change, Uh, the Supreme Court recently emphasized that consumption of sexually explicit content involving minors is a severe criminal offense. Now, why did this happen? Primarily because there was a controversial decision by the Madras High Court, which held that passive consumption of child pornography did not constitute an offense under POSCO. And there was a lot of hue and cry about this, or Information Technology Act, because of which the Supreme Court stepped in and made a lot of changes and has clarified the position of the country has to currently follow. Now, let us discuss the Supreme Court decision. The bench led by the Chief Justice of India expanded actually the interpretation of Section 15 of the POSCO Act. Now, what does the Section 15 of POSCO Act say? It punishes any person who stores, possesses pornographic material in any form involving a child with an intention to share or transmit child pornography for commercial purposes, etc. And there was a 3 to 5 year jail sentence. So this is how it was earlier. Now, the courts have strengthened it further. Now, what the Supreme Court said is, Section 15 is not a limiting act, is not limited to punishing merely sharing or transmitting of child pornography, but can also be used for intent. Intent to commit such a crime is also a serious offense. This is what the Supreme Court has expanded. Earlier, the intent was missing. Earlier, intent was kind of glossed over. Court held that failure to delete or destroy or even report child pornography would allow the court to indirectly infer that the concerned individual intended to share or distribute under Section 15. So this is a major change that has come in. Now, the other thing is, this also means that the Madras High Court judgment is no longer valid. Madras High Court judgment stands invalidated. And the Supreme Court has expanded the possession in the case of child pornography. Individual may not have physical possession of child pornography material. However, when they have the power to control the material in question and the knowledge of exercise of such control, they can be held responsible. So this is the other interpretation that has come in. It has added another layer to it. Now, the court has termed this constructive possession. Now, this is an important concept. Please remember this. The idea that even if you do not have physical possession of it, if you're in control of it through some means or the other, that is called constructive possession, and person can be sent to prison for that. So, and they held that viewing, distributing or displaying such material would still amount to being the accused's, being in the accused's possession, and under Section 15 they'd be held accountable. Now, these are all coming from a serious set of problems that have cropped in. We'll discuss that, but let us first see this. Now, like I said, the interpretation has been expanded. Punishment is for storage of pornography involving children. Any person who stores or possesses pornographic material involving a child but fails to report, delete, destroy or report the same with an intention to share or transmit child pornography can be held responsible, can be brought to law, can be sent to prison, 3 to 5 years. Any person who stores or possesses such material in any manner except at the time of reporting or use as evidence in the court. So this is the only time somebody is allowed to actually physically possess this kind of pornography. These are called inchoate offenses, or rather in anticipation of or preparation for committing such a crime. This is the idea that the courts have brought in. So one, we have constructive possession and the other inchoate possession. Please remember these concepts. This will be quite useful either as a question in prelims, or if you're writing an essay or you're writing anything. Please don't forget to use these two phrases, constructive possession and inchoate offenses. Inchoate is with the idea that you might actually, it's a preparation or anticipation of a crime. Now, how will such cases be registered? The court held that the intention of the accused will be determined based on the circumstances And actions like storing, not deleting can be used as evidence of intent to share or distribute. Now, section 15 says that even if a specific offense isn't made out, police should explore the possibility of other violations under other sections. This is what the Supreme Court has said. Now, reporting is now obligatory. Court emphasized the mandatory reporting of child pornography, and failing to report starts from a fine of 5,000 rupees and increases for further offences, and even after merely viewing it, somebody doesn't report can result in legal consequences. So this is where the courts have completely expanded the definition under section 15 and have made things much more clearer. Now, the Supreme Court has also made some suggestions to the center about what needs to be done, and let us look at those suggestions. Now, what they have said is to replace the term child pornography with child sexual, exploitative and abusive material. They are saying amend the POSCO Act to have this. It reflects better the nature of the crime, and help victims to heal and integrate into the society by providing psychological counseling or therapeutic interventions and educational support to the victims. Now, introducing cognitive behavior therapy for the victims to help address the cognitive distortions fuel such behavior among offenders. So they basically are saying both for the children who are affected by this and both for the offenders, so that they can be reintegrated into the society. Now, promoting coordinated efforts among educators, health care providers, law enforcement to identify individuals with problematic sexual behaviors and to ensure early interventions to stop this problem. Raising awareness through public campaigns, that is what the courts have said, and formation of an expert committee to devise comprehensive programs to prevent this problem. So this is what these are the suggestions made by the Supreme Court to the center. Now, when we talk about this problem, we have to understand that protection of children from sexual offences, the POSCO Act is an important act, and it is the first comprehensive law in the country which was enacted in 2012. It's administered by the Ministry of Women and Child Development. Basically, it protects children from sexual assault, sexual harassment and pornographic violations. Now, what are the key provisions of this act? It's gender neutral. Non-reporting is a crime. No time limit for reporting abuse, and keeping victims' identities is confidential is a part of the law. Now, what are the concerns? Abuse of children has been on the rise, especially since COVID-19, and there's a lack of awareness among the people. So these are the two major problems. What is the status of crimes against children in the context of this? Now, according to the US-based National Center for Missing and Exploited Children, NCMEC, India now accounts for the maximum number of online child and sexual abuse imagery in the world. India is number 1. This is a horrifying statistic, and we should not be topping this. We are followed by Thailand, which has long been associated with problems like this. But India has now reached number 1. We've not been aware of this as a country, and this has basically exploded into a massive problem. Now, NCMEC, the US-based organization, estimates that Indian users have uploaded 25,000 images or videos between just April and August 2024. That's just this year. In a short span of time, 25,000 images have been uploaded. By geographical distribution, Delhi tops the maximum uploads, followed by Maharashtra, Gujarat, Uttar Pradesh and West Bengal. So these are the major states which are actually having this problem in a very serious manner. Now, according to the Crime Reports Bureau, that's our own country, in 2023, there were 781 cases of creating or storing child pornography in 2018. In 2017, there were 331 cases. So basically, in 1 year, you can see that the number of cases have went up massively. This is the report that came out in 2023. This is for 2017. This is for 2018 and this is for 2017. Now, so far in 2022, there have been 1171 cases. So this is where it stands right now in terms of statistics. Now, there have been questions in the past. Like I said, let us discuss the questions when we wrap up a topic. Now, UPSC has asked an exam in prelims in 2017. Which of the following are envisaged by the Right Against Exploitation in the Constitution of India 2017? The answer is 1 and 4, that is prohibition of traffic in human beings and forced labor, and prohibition of employment children in factories and mines. So these are Right Against Exploitation covers these two. Okay. Let us discuss Ayushman Bharat health insurance for senior citizens. Now, we discussed this topic in the previous episode. We discussed this in August. But what we are going to do is, we are going to add on to that, and we are going to add on to that in a way that it allows you to answer a question more critically as to, suppose we want to try and improve this, how do we go about it? What have been the major lapses and why is it necessary? So these are some of the things we'll cover. Now let us quickly recap what we discussed earlier. Now, the Union Cabinet has cleared the expansion of the Ayushman Bharat Pradhan Mantri Jana Arogya Yojana, which is basically an insurance scheme. It covers now all senior citizens over the age of 70. Earlier, there was the economic criteria attached. Now, anybody over the age of 70 is covered under this scheme. Currently, the scheme gives an insurance of 5 lakh rupees for a family. And basically, husband and wife would get 5 lakhs together. Or if there's only one person, that one person would get 5 lakh. Now, irrespective of their age, the 5 lakhs has been given to the families. Now, in its current form, the current scheme estimates about 40% of the population is covered under this scheme. Now, coverage under the new plan, it's again 5 lakhs for a family. Will get an additional share up to 5 lakhs for themselves. That is, senior citizens over the age of 70 will get 5 lakhs. So let us say a husband and wife would get 5 lakhs. If there's only one person alive, that one person would get 5 lakhs. This is an insurance scheme. Now, expansion of this is supposed to cover about 6 crore elderly people from about 4.5 crore families. Now, those benefiting from other insurance schemes like CGHS, ECHS or Ayushman PF can either continue with their current scheme or they can opt for Ayushman Bharat PMJ in case of senior citizens. Additionally, senior citizens under private health insurance policies or the employees' state insurance scheme will also be able to avail these benefits. So this will now be along with that. Suppose somebody has bought an insurance scheme for themselves out of their money, they can continue with that and they can use the benefits from this as well. Now, there will be a new health card given to the senior citizens, which will ensure streamlined access to healthcare benefits. What is the benefit cover under PMJ? Now, let us see the key features that will also tell you what is the benefits. Now, it's the world's largest health assurance scheme. Health coverage is of 5 lakh rupees. Each entitled family gets an annual cover of 5 lakh rupees for secondary and tertiary care hospitalization. Now, that is an important thing. I want you to remember that. This is basically for secondary and tertiary healthcare, and this becomes a point of discussion later. Now, it covers about 12 crore families, cashless access to healthcare. Now, it mitigates catastrophic health expenditure, which we know happens many times in our country. Now, there will be pre and post hospitalization coverage. There is no family size or age restriction. There is coverage from day one of falling ill. There is a nationwide portability, which means that a person with a health card can access any of the empaneled hospitals anywhere in the country. It doesn't have to be in their own state or their own district or anything like that. You can use it anywhere in the country. Now, there's a comprehensive service package across 1,949 medical procedures spanning 27 medical specialties, including general medicine, surgery, oncology, cardiology. Beneficiaries will receive free drugs and diagnostics and food and lodging at no cost, and equal reimbursement for public and private hospitals. So These are the key features. Now, coming back to Ayushman Bharat, so far there have been 35.4 crore cards that have been created. There have been 7.79 crore hospital admissions, and a total sum of 7,125 crores has been spent on this. And over 30,000 hospitals have been empaneled. Now, what has been the impact of Ayushman Bharat? Let us try and understand that. That's an important thing. We have a concept called out-of-pocket expenditure when we talk about healthcare, and we've discussed this in one of our previous episodes, where people spend on healthcare out of their own pockets. And this is something around the world, every government, WHO, everybody is trying to bring this down because this essentially pauperizes people. Now, out-of-pocket expenditure is basically, suppose something is not covered under your medical, say under your insurance or under your employee insurance, anything like that, you have to pay out of your pocket. Those add up, and that can have a devastating effect on people's finances and can actually pauperize people. Now, in the case of Ayushman Bharat, we have seen that there's a 21% decline in out-of-pocket health expenditure. So that is a very good statistic. Now, there's a 8% decline in tendency to borrow emergency loans for healthcare purposes. What do people do when they don't have healthcare? They have to borrow money. And that again, completely destroys families. Now, it covers, the expanded scheme covers all senior citizens, irrespective of their income. It will cover 4.5 crore families with 6 crore senior citizens to be benefited. There's a 5 lakh free healthcare cover. And there will be a new distinct identity card and additional top-up of 5 lakh rupees. So that is the highlight of it. Now, why do we need it? Now, right now, India has something called a population dividend. We have one of the youngest populations in the world, but this is not going to stay like that. This will very quickly change. This is how it's going to change. Now, India's population is rapidly growing. And right now, about 10% of our population, 10.7% actually, are senior citizens. Now, this will double by 2050. 2050, you'll have 20.8% people who are senior citizens. That is people over the age of 60. Now, by 2100, 36.1%. That is more than 1/3 of the population will be over the age of 60. So we have to get ready for that eventuality, and that is what the government is doing. Now, there'll be 300 million elderly by the year 2050. Now, 30 years from now, elderly population, which is right now about 104 millions, will triple to 300 million. Now, right now, the 134 million people who are over the age of 60 in our country, it's the size of the population of Mexico or Russia. It's nearly the size of population of 2 major countries. Now, by 2050, there will be more elderly people in our country than the entire population of the United States. Now, in the case of India, right now, people over the age of 80, there are 12 million people. That is about the same population as the countries like Belgium, Greece, or Cuba. So we have an aging population that has to be taken care of. So this is a really good reason and a very important step the government has taken. So this is the primary reason. Now, if you compare the decadal growth in elderly population compared to that of the general population, you will see that it is increasing over a period of time. Now, most of the healthcare expenditure. So, how do we go about improving the present scheme? Like I said, we are going to focus on that. Most of the healthcare expenditure by the elderly will therefore be through outpatient care. It will be an outpatient care, which is about 40 to 80%. Unfortunately, that is not covered by the scheme. So, it is probably necessary at some point of time. Outpatient care will also have to be included in the Ayushman Bharat scheme. So that would be one point for improving it. Now, life expectancy in India is increasing. When we became independent, it was about 32 years. In 1951, it was about 35 years. Right now, In 2023, it is 70.42 years. Now, increased life expectancy means an early onset of these diseases would mean that people over 70 may easily suffer from chronic illnesses. This will have to be covered under Ayushman Bharat scheme. Like again, substantiating the point about we have to have outpatient care also covered under this scheme. Now, there are other minor problems with the scheme. Marginalized populations are not able to use the scheme properly. So if you see this, admissions in population in private hospitals as a percentage of total private hospitalizations, you'll see only 4% of Dalits are able to use it. And only 1.6% of tribal people are able to use the Ayushman Bharat scheme for actually going into private hospitals. So this will have to be taken care of. Now, the other problem with the other thing that has to be improved in Ayushman Bharat scheme is smaller cities and towns have not really been able to use the Ayushman Bharat scheme. So that is one thing we'll have to improve in the times to come. Now, the other thing, like I said, is in terms of the number of people eligible for healthcare, the marginalized populations are not able to use it. Now, there is also another problem with the Ayushman Bharat scheme. There is a divide in the country when it comes to healthcare, that primary healthcare facilities are much better in the southern part of the country than the rest of the country. So, that also means that when we are leaving out secondary and tertiary, then we are covering only a secondary and tertiary care. The majority of the country is actually not able to benefit from healthcare the way they should. So what's happened is we are using the American formula for providing healthcare, where we pay for insurance. The government pays for insurance, and then you can choose wherever you want. However, it might be better to follow some of the Southeast Asian models, like the models followed by Thailand, where we actually invest in primary healthcare facilities as well. Now, our primary healthcare, we have focused a lot on vaccinations, inoculations and things like that, and that has been a fabulous success. We have extraordinarily good rates of vaccinations. We also have very good Anganwadi workers and Asha health workers who are actually helping people take care of health needs. Now, that, however, something similar we probably need to bring in for primary health care. Now, if you see this statistics actually shows you the number of allopathic doctors are much, much higher on the lower parts of the country, in the southern states and Maharashtra, than in the other states. So this is something we need to, this also tells you actually the kind of healthcare that is also available. Now, to just sum up the major points, there's a north-south divide in Ayushman, in the healthcare facilities available in the country. Southern states tend to have better primary healthcare, and Ayushman Bharat is not covering the primary healthcare because of focus on tertiary and secondary and tertiary care, which is actually destructive in terms of the cost it entails on people's pockets. So it's a good part of it, but we also need to focus on primary healthcare. Now, the other thing is, there is another problem that has cropped up because of the nature of healthcare that is being taken care of. Now, there is a NHA policy that says that most private hospitals are empaneled for surgical packages and are more strongly oriented towards tertiary care. Now, these private hospitals also dominate super specialties such as cardiology, cardiothoracic and vascular surgery, neurosurgery, and almost two-thirds of the hospitals, two-thirds of the private hospitals are for surgical packages. Now, this is a concept called cream skimming. What this basically means is the private hospitals are looking to basically take only those cases which they can cure and for which they can get paid big sums of money, instead of actually providing healthcare to everybody. So what they do is, relatively safe cases are admitted, profitable and safe cases are admitted, and critical cases are refused. and relatively safe patients. Now, this basically means that critical end-of-life healthcare is going to the public sector. So, the private sector is not really taking the cases in a balanced way to serve the poor. This whole Ayushman scheme is basically about taking care of the health needs of the country by involving the private sector as well. But the private sector is looking at this as a way to make money. So this is something that needs to be, this is the NHA policy paper that has come out, and that is what the paper has pointed out. So this is something that has to be corrected at some date. Now, these are some of the problems with, these are some of the areas where Ayushman Bharat can be improved, and this is actually an essential scheme that is necessary and will actually continue to serve the country quite well in the years to come. So I hope the discussion was useful for you, and thank you very much. Best of luck for your preparation. Thank you so much. I'll see you again in the next episode.